Yusavale back again. Got another video for you. And first of all, I want to give a shout out to all the trolls. I appreciate the research that you're doing because it's really helping me when I, look at these cases that you send me. I just get so much information because obviously your ass didn't read it. Or if you did, you know what the hell you was reading because you definitely wouldn't have sent me this right here. Hugo versus the United States. This is a good case. Everybody write this down. Now, let me give you the background. I have a troll. He was telling me, you know what they do. Y'all sovereign citizens is crazy. This is not commercial. These district courts are Article 3 courts. You don't know what the fuck you're talking about. It's just like all last 30 years, all the intelligent people who've been doing research into all of this just doesn't warrant attention. Y'all are just delusional. There's something in the water that so many people would be saying this. I don't know why so many people are saying this, but instead of the fact that the people on our side, we're the one doing the research and reading. The people on their side are the ones playing Xbox and video games and going to work every fucking day and not reading a goddamn thing. I haven't even looked at the Constitution. But so as things go. So let's get into this. I'm going to read this real quick. Okay. I want y'all to pay attention. United States Court of Appeals, 7th Circuit. Ross HUGI petitioner appellate versus United States of America respondent appellee. January 7, 1999. Before Flom, Easterbrook, and Diane P. Wood. Now, I want to stop real quick. 1999 wasn't no internet. A lot of this stuff wasn't going on the way it is now because you don't find judges saying a lot of stuff now. They'll say, we have repetitively denounced this. And I'm okay, where's the Supreme Court? When you go back and look at the cases, you got to read these cases. When these guys throw cases up in your face, read them and read them like I'm about to show you right now. I'm going to show you how to read this case. Okay. Before Flom, Easterbrook, and Diane P. Wood, circuit judges Stephen L. Popak argued, and Popak and Associates, Chicago, Illinois, for petitioner appellate. Ted Chung argued, Office of the United States Attorney, Criminal Division, Chicago, Illinois, for respondent appellee. Richard Bailey and his henchmen operated a decades-long scam in which they fleeced wealthy but lonely women. Helen Voorhees Branch, one of the victims, was murdered to prevent her from alerting prosecutors, and for this Bailey is serving life in prison. United States versus Bailey. Okay. Other victims were often left brokenhearted and destitute. Okay. Ross HUGI, one of Bailey's henchmen, was a veterinarian associated with the stables that served as the scheme's focal point. HUGI cooperated with prosecutors between 1990 and 1994, helping them build a case against Bailey. As a reward for this assistance, HUGI was allowed to plead guilty to a one-count information charging him with fraud in violation of 18 U.S.C. 1343. Now, he's offered substantial assistance to the government. It's called a Rule 35. It's called a Rule 35. Snitching. You snitch on somebody, you get time off. And you see what time he got. He got what? He snitched. He did 6 months. Yeah, these snitches, they do a real short amount of time. My man got life in prison, but he killed somebody. He killed someone. That someone is really injured in that instance. It's called a malum in se crime. It's not mala prohibita. This is malum in se. And very difficult to use a commercial defense when you've actually killed someone. Everyone take note. His sentence was a modest 6 months imprisonment plus 3 years supervised release, a $22,000 fine and restitution. Having served the imprisonment and confident that the statute of limitations has run on any other crimes he may have committed, HUGI now contends that he should not have been convicted in the first place. Because, you come back and they find something else on you, they'll bring that up. But he didn't come back to after 7 years. There's a point to that, okay? Because we have what's called latches in equity and everything. He who sleeps on his rights weighs them. So it goes on, it says, the information alleged that HUGI and Bailey cooperated to defraud victim J of $50,000. Bailey told HUGI to prepare a document that purported to obligate Bailey to buy 4 horses from HUGI for $60,000. According to this document, Bailey had made a $10,000 down payment, which he would forfeit if he did not produce the remaining $50,000. This deceit persuaded victim J to lend $50,000 to Bailey, who gave $20,000 of this to HUGI for his role in the deceit. Bailey never repaid the loan, but defaulted and left victim J with a security interest in 4 mares that were not worth close to $50,000. Bailey and Confederates then induced victim J to pay inflated boarding expenses for her collateral. So much for the fraud. As for the wire element, according to the information, victim J came to Bailey's attention when she responded to a Lonely Hearts ad Bailey had placed with the Pioneer Press. Bailey paid for the advertisement by credit card. This is an element that grants jurisdiction, all right, using the Federal Reserve System. And Pioneer Press verified the charge by interstate wire communication. Okay, so you have a company that he used something else that belongs to the government, their wire system. HUGI was allegedly accountable for the entire scheme, including the wire component. Okay, so he didn't pay for an advertisement. He done ran an advertisement. They got proof of it. Okay, so he's doing fraud. All this is commercial. Okay. HUGI pleaded guilty and filed with the court a written plea agreement that conceded every allegation of the information and then some. This is important. He pleaded guilty. A guilty plea kills all known and unknown defenses. All right, these judges are stating all this. This is just a statement of facts. HUGI agreed that he knew Bailey to be a con man, helped him gold victim J, and kept $20,000 of the pelf. HUGI agreed that an interstate wire communication occurred on July 27, 1989, when Pioneer Press verified the charge. Okay, so he agreed to all of this. HUGI also acknowledged that it was foreseeable to him that interstate wire communication facilities would be used by Richard Bailey in furtherance of the scheme to defraud. Why are they talking about interstate wire communication facilities? These are corporations. You go into a law library and pull the United States Code annotated off the shelf. Almost every case in there is some sort of corporation. Go in there and look. So it goes on. It says Thomas Foreign, who represented HUGI between 1990 and the guilty plea, withdrew in January 1995 and was replaced by Stephen Pupak. Sentencing did not occur until October 3rd, 1995, more than 13 months after the guilty plea and approximately 81 and 2/12 months after Pupak appeared. Okay, so now we give him the time frame. Remember what I said about latches. Pupak remains HUGI's counsel in this petition for relief under 28 U.S.C. 2255. This is a statutory habeas. This is a federal habeas for after conviction. Asserting that Pioneer Press, now what he asserted? He asserted that Pioneer Press had not used interstate communications to verify the charge. HUGI contended that the district court therefore lacked jurisdiction and that Foran's failure to discover this shortcoming amounted to ineffective assistance of counsel, which is what 95% of the people in federal prison try to get back in court on, because the attorneys don't never do nothing for you. Moreover, HUGI insisted any verification of the charge must have occurred before July 27, 1989, so the 5-year statute of limitations barred the prosecution, which began on July 27, 1994. And again, HUGI blamed Foran for his failure to raise this affirmative defense. But the district judge held these contentions forfeited because HUGI failed to present them during his 81 and 212 month between Foran's replacement and sentencing. You had plenty of time to bring this up. Why didn't you? Okay. The judge remarked, there is no contention that new counsel provided ineffective assistance to HUGI or that new counsel could not discover the presently claimed weaknesses in the government's case until after HUGI was sentenced. You ain't even brought this up. You didn't even contend this. It's not even in, because people don't know how to write pleadings and stuff like that. Neither is there any allegation that prior to sentencing, new counsel failed to advise HUGI regarding these potential defenses. None of these things were alleged. The judge granted a certificate of appealability limited to the ineffective assistance issue, observing that the substantive contentions HUGI sought to raise are not of constitutional dimension and therefore may not be raised on appeal under 28 U.S.C. 2253. I don't know why he didn't say 2255 up here, but I haven't read this code yet. But anyway, we may add issues to a certificate of appealability. See Sylvester Basis Hanks. He gives you the case law that supports their ability to add issues. Okay, so I can add something. Judge is telling you I can. Here's the law that says, the case law that allows me to add something. And HUGI asked us to add his jurisdictional objection. Some jurisdictional shortcomings are constitutional in nature. For Article 3 in the 11th Amendment set limits to the duties Congress may assign to courts. Okay, we're talking about Article 3, Section 2. All right, sets limits that may assign. Now, what does he mean? This has been expressed anyway, sets limits. Okay, what does this mean? It's always talking about it's a limited jurisdiction. Congress has a limited jurisdiction. That limited jurisdiction is within that 10-mile square in Washington, D.C. and all their insular possessions. Article 1, Section 8, Clause 17. Okay, the delegation of powers that Congress has is under Article 1. Okay, they can only exercise powers that have been delegated to them. They cannot exercise a power that has not been delegated to them. All right, and that is in that list right there in Section 8. Okay, under Article 1, Section 8, Clause 3, they have the ability to regulate interstate commerce. Under Article 1, Section 8, Clause 9, they can make tribunals that are inferior to the Supreme Court. Okay, this is what they're doing. And this is an allowance that's being spoke about in Article 1, 3, Section 2. I got a case where a judge tells us that these people need to stop this. This is ridiculous. Separation of powers doesn't allow the federal courts to exercise judicial power. It's not a judicial power that they're exercising. They're exercising an administrative. It's called judicial. And he's going to give me a case where this judge is going to talk about this a little bit. Okay, so it says limits may assign to their courts, delegation, assign, delegation of powers doctrine. Other jurisdictional deficits are just the result of statutory limitations. All right, they got a limitation. The statute doesn't allow them, they can only go so far. But the contention HUGI wants to advance is not jurisdictional in either sense. Okay, this judge just gave you everything. This is why I like reading case law, because the judges will tell you what you should be looking at. He gives you all the jurisdictional shortcomings and everything. Now, we're not talking about jurisdiction. We're talking about subject matter jurisdiction. What's the subject we're talking about? It's commerce. I'm going to tell you right now. Subject matter jurisdiction in every federal criminal prosecution comes under 18 U.S.C. 3231. And there can be no doubt that Article 3 permits Congress to assign federal criminal prosecutions to what? Federal courts. Okay, and now we are at the Legal Information Institute. Now we're looking at federal question jurisdiction. Overview. Federal question jurisdiction is one of the two ways for a federal court to gain subject matter jurisdiction over a case. The other way is through diversity jurisdiction. Generally, in order for federal question jurisdiction to exist, the cause of action must arise under federal law, i.e. statute. More specifically, however, there are both constitutional and statutory requirements that must be met before jurisdiction can be found. Okay, interpreting arising under constitutional requirements. Now here goes the tricky language. Under Article 3 of the Constitution, federal courts can hear all, and they put in quotation marks, all cases in law and equity arising under the Constitution. Notice how they labeled law and equity with small letters, not capital. Look in the Constitution, they're in capital letters. This is a colorable jurisdiction. And the laws, small l, of the United States. United States is not the United States of America. That's a different entity. That's a corporation. U.S. Constitution, Article 3, Section 2. The Supreme Court has interpreted this clause broadly, finding that it allows federal courts to hear any case in which there is a federal ingredient. Federal ingredient, what is that? Osborne Bank, United States. Okay, got this, the case law there. The statutory component. For federal question jurisdiction to exist, the requirements of 28 U.S.C. 1331 must also be met. The statute gives federal courts jurisdiction only to those cases which arise under federal law. 28 U.S.C. 1331. This requirement has been found to be narrower than the requirements of the Constitution. It's a narrow requirement. The Supreme Court has found that a suit arises under the law, small l, that creates the cause of action. The law that creates the cause of action. All right, in this case, they got the case law supporting it, and then the case law supporting it, And therefore, only suits based on federal law, not state lawsuits, are most likely to create federal question jurisdiction. Not the only thing, but it's the most likely thing. Well pleaded complaint rule. Typically, in order to have federal question jurisdiction, the plaintiff's complaint must be a well pleaded one. This means that the plaintiff's initial complaint must contain the references to the federal question and the federal issue evoked. The federal question and issue cannot arise in an anticipated defense. It must be presented from the initial complaint. This requirement was established in Louisville versus Nashville. Okay, why are we reading these cases? Because in all these cases, you're going to find the federal question jurisdictional elements contained in all of these. And it's always going to be based off of what? Subject matter jurisdiction. Which are these Article 1 courts? It's all under their jurisdiction. This is a statutory violation. You are in interstate commerce. You use a minimum contacts. That's what it is. You came into the flow of commerce by using these Pioneer Press to verify a charge. Okay. All right, you did that. You got involved in interstate wire fraud, using all these commercial things, all right, to conduct this crime. You put an ad in the paper. You used a credit card. Okay, these are all called minimum contacts that give jurisdiction. Where is minimum contacts? All right, so let's keep going. It says we may add issues to where am I at? Okay. Subject matter jurisdiction is in every subject matter jurisdiction in every federal criminal prosecution comes under 18 U.S.C. 3231, and there can be no doubt that Article 3 permits Congress to assign federal criminal prosecution to federal courts. That's the beginning and end of the jurisdictional inquiry. Lawyers and judges sometimes refer. Now he's going to give you an explanation of this subject matter jurisdiction. We're not talking about jurisdiction. We're talking about subject matter. This is how the federal courts get their jurisdiction. The subject. Well, what are we talking about? We're talking about commerce. This comes within the sphere of Article 1. And it can be referred to their tribunals, which are federal courts, which they do go all out to hide this fact from all of you. Lawyers and judges sometimes refer to the interstate commerce element that appears in many federal crimes as a jurisdictional element. But this is a colloquialism or perhaps a demonstration that the word jurisdiction has so many different uses that confusion ensues. Now, he gave this case, and you might think KANAR versus the United States is kind of downing the fact that that interstate commerce is the jurisdictional nexus. Well, let's look at KANAR versus the United States, see what it says. Okay, and here we are, KANAR versus the United States. Okay, United States Court of Appeals, 7th Circuit. Melvin KANAR, plaintiff appellate, United States of America, defendant. Okay. And this is before Posner, Chief Judge in Easterbrook and Mannion. Okay. And let's see what it was. They framed the claims. It's bad. No one may file suit under the Federal Tort Claims Act without first making an administrative claim. All right. It has to be an administrative claim. Okay. And this is an act we're talking about. Okay. So let's go down here. And you're going to see where the judge talks about jurisdiction right here. All this right here. We're going to read this. Real interesting. All right, it says, jurisdiction in its strongest sense is a case or controversy within the meaning of Article 3. Okay, all right. Now, that's how Article 3 gets that, to be case or controversy. No one today doubts that Article 3 courts may entertain suits against the United States seeking money damages, although this was one doubtful given Congress's ability to pay up because they, what? Bankrupt. Okay. Both of which have been repudiated in Glidden versus Company, showing a contravening case. All right. Though a majority of the court was unable to agree on a rationale to replace them. Another slightly weaker sense of the term is the statutory grant of adjudicatory power. Okay. So we're talking about jurisdiction. Another slightly weaker. It's not weak, but just slightly. Okay, when they are what? Statutory grant of adjudicatory power. They use this word judicial, but it's adjudicatory in nature. Okay, they're just resolving controversies within their sphere of plenary power that they had from their sovereign capacity within Article 1 of the Constitution. So it goes on, it says, these are the two senses of jurisdiction that may not be stipulated or waived by the parties. although pendant an ancillary jurisdiction, now codified in 28 U.S.C. 1367 as supplemental jurisdiction. Okay? But for a long time, a common law development, plus the concept of jurisdiction to determine jurisdiction, show that the requirement of a statutory grant of jurisdiction has some fuzziness at the edges. Yeah, I'll agree with that. It is very fuzzy. No one clearly sees the edges. At all events, subject matter jurisdiction over KANAR's case is secure. However, ain't no fuzziness right here in KANAR's case. Section 1346B1 of the Judicial Code creates jurisdiction to decide cases under the Federal Trade and Commerce Act, I guess. Law teams with weaker uses of the word. Courts need jurisdiction over the person of the litigants, but they may waive their requirement or forfeit it by objecting belatedly. All right, you ever heard of the belligerent claimant? I'm posting it all the time, the belligerent claimant. Okay, so belatedly means when you don't object on time. Right here it tells you, but they may waive this requirement or forfeit it by objecting late. Courts need jurisdiction over the person of the litigants, but they may waive this requirement or forfeit it, but you got to object to the jurisdiction. Then there is a tendency to use jurisdiction to refer to the lack of a claim for relief, though cases such as Bell versus Hood caution against equation of the two. Courts often use the word to denote the allocation of authority among coordinate parts of the judicial branch. See Peretz versus United States. Jurisdiction is appropriate as a shorthand for the commerce element in many federal statutes, which may require proof that acts were in or affected interstate commerce. See United States versus Lopez. And in the loosest sense of the word denotes any condition precedent to the plaintiff's ability to prevail. So right here you can see this word commercial element. You look in every federal indictment, I guarantee you're going to see it violated interstate commerce. That's it. All right, that's it. All right, this case is telling you what it is. All right, right up, let's go back up here. Jurisdiction in the strongest sense is a case or controversy within the meaning of Article 3. No one today doubts it, okay? All right. Okay. But when you get down here, when it talks about KANAR's case, you can see right here it says, at all events, subject matter jurisdiction over KANAR's case is secure. We have two senses of the word jurisdiction. What do we ask them in court? Is this civil or criminal? Okay. And they say it's criminal. Okay, thank you. Let the record reflect that the action being brought against the defendant is criminal. Now, sir, for the record, the Constitution for the United States of America only grants this court two criminal jurisdictions. One is under the common law, and the other constitutes the condition of contract on the criminal aspects of a colorable admiralty jurisdiction. This statutory grant that they got of adjudicatory power. You can look and see how did Congress get this ability to get admiralty jurisdiction. Go and look it up. Okay, we want to know which one of these two jurisdictions are you trying this. You never get an answer to that question. As a matter of fact, they might charge you for contempt just for asking it. This is all commercial. 27 CFR 72.11. Let this congressman and this judge tell you real quick.
So let me ask you the question, is there also a role for the courts? Can you foresee a role for the courts in other situations in which Congress, some future hypothetical Congress, might do something different that would prove easier and more efficient and more collegial, but perhaps in a way that's antithetical to the Constitution? For instance, let's suppose that Congress, when legislating on the delicate and pressing issue of maintaining the proper records in the dog breeding industry. Since we're talking about federal legislation, these would of course be dogs either moving in commerce. Since we're talking about federal legislation, these would of course be dogs either moving in commerce. Since we're talking about federal legislation, these would of course be dogs either moving in commerce. Since we're talking about federal legislation, these would of course be dogs either moving in commerce or taking advantage of some channel or instrumentality of interstate commerce, or taking advantage of some channel or instrumentality of interstate commerce, or taking advantage of some channel or instrumentality of interstate commerce, or taking advantage of some channel or instrumentality of interstate commerce. But a law in which Congress just passes a law saying we're outsourcing, we're delegating the authority to regulate dog breeding. We're outsourcing, we're delegating the authority to regulate dog breeding. We're outsourcing, we're delegating the authority to regulate dog breeding. We're outsourcing, we're delegating the authority to regulate dog breeding. We're outsourcing, we're delegating the authority to regulate dog breeding and record keeping for purebred dogs to the Board of Directors of the American Kennel Club. That passes both houses of Congress. It goes to the President. It's signed into law, and we then have outsourced the regulation of this practice to the American Kennel Club. Is that a situation in which you can anticipate the court might step in?
Well, I would step in. I don't know if the court would. I was the dissenting vote in the first case involving. I hate to mention this with my friend Stephen here, since he was on the Sentencing Commission. I thought when Congress created a Sentencing Commission to decide how many years everybody should spend in jail, because presumably Congress didn't have the time to figure it out for themselves and just left it to this commission to do it, I didn't think that that was constitutional. When Congress created a Sentencing Commission to decide how many years everybody should spend in jail, because presumably Congress didn't have the time to figure it out for themselves and just left it to this commission to do it, I didn't think that that was constitutional. When Congress created a Sentencing Commission to decide how many years everybody should spend in jail, because presumably Congress didn't have the time to figure it out for themselves and just left it to this commission to do it, I didn't think that that was constitutional. When Congress created a Sentencing Commission to decide how many years everybody should spend in jail, because presumably Congress didn't have the time to figure it out for themselves and just left it to this commission to do it, I didn't think that that was constitutional. When Congress created a Sentencing Commission to decide how many years everybody should spend in jail, because presumably Congress didn't have the time to figure it out for themselves and just left it to this commission to do it, I didn't think that that was constitutional. When Congress created a Sentencing Commission to decide how many years everybody should spend in jail, because presumably Congress didn't have the time to figure it out for themselves and just left it to this commission to do it, I didn't think that that was constitutional.
Wake up, people. You're going to see this word commerce about 1 million times. A link to interstate commerce may be essential to Congress' substantive authority. A link to interstate commerce may be essential. Now, this word may means must, okay? Tricknology. Let's look at that word real quick in Black's Law Dictionary. Trolls, are you paying attention? Okay, and remember what I told you about 3 being a magic number? Here you go again. May. To be permitted to, the plaintiff may close. Second one, to be a possibility, we may win on appeal. Or 3, loosely is required to, shall, must. If 2 of the defendants are jointly indicted, any defendant who so requests may be tried separately. Must be tried separately. In dozens of cases, courts have held may to be synonymous with shall or must, usually in an effort to effectuate legislative intent. There you go. We're talking about commerce again. Okay, so this word right here is one of the most deceptive words in law, and herein lies the evidence of how these people that sit up and watch Xbox all day and just read these laws as if the words in it mean the same thing in everyday parlance. You got to look up every word in these things because they are so deceptive. May means must. And usually when you look up a statute and you see this word in here, you need to go to the law library and look up, like get a United States Code annotated and look at the case law that supports the statute. And a lot of times they'll give you the definition of the spirit and intent of what a particular word means in that statute. May means must. So here we are back again. A link to interstate commerce must be essential to Congress's substantive authority. A link to interstate commerce must be essential to Congress's substantive authority. See United States versus Lopez. But the existence of regulatory power differs from subject matter jurisdiction of the courts. United States versus Martin clarifies this point by holding that proof of an interstate transaction is no different from proof of any other element of a federal crime. The nexus with interstate commerce, which courts frequently call the jurisdictional element, is simply one of the essential elements of the offense. Although courts frequently call it the jurisdictional element of the statute, it is jurisdictional only in the shorthand sense that without that nexus, in other words, we've given up the broad meaning and the narrow meaning of jurisdiction. The shorthand or narrow meaning of it is that it only means it when you have that nexus, which means connection, there can be no federal crime. Okay, without that nexus, without what nexus? Commerce, interstate commerce. Every federal indictment you look at is going to say violated interstate commerce. I don't know why this troll gave me this case. This is just, I'm doing this to show you these trolls, either they know this or they hoping we don't know it and we won't sit down and go through it like I'm going through it with you right now. They think they can just throw a case at me. See here, this proves my point. Now, I don't prove a motherfucker. It's proving my point. And I appreciate you. Thank you very much. Y'all can read the rest of this case. Because I think after this paragraph here, like he says, no more need be said to demonstrate that the district judge limitation. I'll finish reading this paragraph. Although courts frequently call it the jurisdictional element of the statute, it is jurisdictional only in the shorthand sense that without that nexus, interstate commerce, there can be no federal crime. It is not jurisdictional in the sense that it affects a court's subject matter jurisdiction, i.e. a court's constitutional or statutory power to adjudicate a case, here authorized by 18 U.S.C. 3231. Okay, Martin, and because they wear two hats. They wear a constitutional hat and a statutory hat. When it's on the statutory, they're acting as an administrator. The federal courts have not been granted any judicial authority due to separation of powers. And I'm going to have to go and start reading those cases to explain to these idiots that, because they don't understand what they're reading with that either. Okay? Even if the government fails to establish the connection to interstate commerce, there it goes again, the district court is not deprived of jurisdiction to hear the case. It can hear it, all right, but you can't give a ruling if you don't have subject matter jurisdiction. HUGI pleaded guilty. Okay, you pled guilty. All right, this is why he's saying it. A guilty plea does what? Kills all known and unknown defenses. This is why this judge said that. It ain't about him challenging jurisdiction. This whole case is about the fact that you pled guilty. You pleaded guilty and admitted all the elements of the offense. No more need to be said to demonstrate that the district judge's limitation on the certificate of appealability was proper. End of discussion. What are these trolls talking about, y'all? Listen. I spend a lot of time. I need to be on, SPC University website, making videos and things like this. But this is necessary. I have to stay sharp, and because these trolls, they everywhere. But let me tell the trolls something. Truth wills out. You can't cover the truth. There's a legal maxim that says the truth fears only to be covered. You can't cover. The truth is always going to uncover itself. It's going to come out. You can't go against God. Woe unto you lawyers. Okay? You ain't finna go against that. What's wrong with you? Only thing I can think of people who would do that is people who've lost their soul, who just don't care. They're thinking, well, I lost my soul anyway. I might as well deceive them and do what I need to do and try to get all I can get while I'm alive right now and live on this planet to the best of my ability. I'm going to get some stuff on selling souls too, because this is what we are contending with. Evil in high places and so forth like this. And these judges, but you know what? These judges, I read a lot of case law, and man, when you read the case law, you can tell who's a good judge and who's not. Like, I think this judge right here was a pretty good judge. This guy gave me this case thinking that he was disproving my point about the commercial jurisdiction or the commercial nature of the cases. And I'm like, did you even read this? Peace to all the gods. I'm Yusuf. See you on the next video. I'm out.